The American Creed. I believe in the United States of America as a government of the people, by the people, and for the people, whose just powers are derived from the consent of the governed, a democracy in a republic, a sovereign nation of many sovereign states, a perfect union, one and inseparable, established upon those principles of freedom, equality, justice, and humanity, for which American patriots sacrificed their lives and fortunes. I therefore believe it is my duty to my country to love it, to support its Constitution, to obey its laws, to respect its flag, and to defend it against all enemies. Father, as we gather here together in this classroom, we ask that you guide our studies and lead us to understanding. We also ask that you protect the individuality of each student as they question and ponder your word in these matters. Thank you, Father, for this beautiful place of learning. We pray these words in the name of your Son, Jesus Christ. Amen. All right, welcome back to Bridge Academy. This is Miss Krewalt, and we are on Unit 1, Lesson 7. And now that we've got the 3 branches established by the U.S. Constitution, we're going to move on to the remaining 4 articles, and that's going to cover this federalism structure that has now been set up, and as well as we're going to talk about the process for amending the Constitution that was provided for by the framers. All right. And when you're starting to think about this concept of federalism, first of all, federal means, in Hebrew, means pledge. So we're starting with a bond here, a vow, with someone or between 2 people. Federalism, when it's applied to government, implies that hierarchical relationship between the federal government and the state and local governments that are considered components underneath it. So each of them has their own power, but they also share powers and responsibilities. And that's that concept of federalism, that yes, the states have their own powers, the federal government has its own powers, but they also share powers between them, and that's where you need this pledge or this vow between each other, because you're going to have to work within this framework as like a family unit. Now remember, on that very first lecture, we talked about hierarchy of power, and along with that hierarchy, we talked about a moral code. What's important about that now is that now that they've set up, we no longer have separate sovereign states that have no, kind of common banner. Now we have this family structure and this family hierarchy we're working within. The federal government may be at the top of that power structure, but above them, and this is where the moral code comes in, is that rule of law, which is the Constitution now. So that's what's significant about that first lecture, because what are you going to use as a guideline for executing powers amongst yourself and over people? What moral code are you going to set as your standard for executing that power and keeping that power in check? And for the founders, it had to be this setup as a republic, to where not only do we have a hierarchy of who's governing, we have a superstructure that is a moral code, and that is the law. Okay, without further ado, we're going to go right into Article 4, which basically covers interstate relationship. Section 1 is the full faith and credit clause, which basically ensures that state courts would honor the judgment of other state courts without having to retry those cases. So, someone can't just kind of cherry pick where they're going to have their case tried because one state may be more favorable over another state. Once one state's court makes a judgment, that is going to be honored by all the states. All right, Section 2, the Privileges and Immunities Clause. This clause protects the individual's fundamental rights when they're traveling over state lines. That means those rights and privileges are portable with the individual when they move throughout the different states of the nation. You can't say that, oh, you cross the line, now you're subject to our state's individual or fundamental rights. It doesn't work like that. There's a superseding understanding of what each individual's rights are. All right, Section 2 also talks about extradition, and we talked about extradition, a couple of lectures ago. And basically, criminals that flee from one state where they're charged with a crime must be returned to the offended state if the governor requests that prisoner be brought back to them. Remember, extradition was important under the Articles of Confederation because they wanted to make sure other states weren't harboring criminals and keeping them from justice. So this again is being carried over from the Articles of Confederation. Now, you can carry this concept of extradition a little further too when it comes to like child custody cases. Sometimes you'll have a parent who doesn't have the custody of a child and will try to cross state lines to flee that custody ruling. But that just doesn't work. I mean, child custody cases are respected between the states as well. So if a parent and a child that whose custody belongs with a parent in a different state, and another parent and the child is found in another state, that all has to be rectified. That child has to be returned back to the custody of the original state of jurisdiction. And sanctuary cities fall under this heading as well. Legally, if one state or one city is harboring an immigrant that is not legally here, that is still illegal under the law. You cannot aid and abet a criminal, which is basically an immigrant who is not legal, is here illegally. There is a lot of unconstitutional behavior going on, I perceive, with these sanctuary cities. And unfortunately, they have the judicial system supporting them in some cases. You have courts that are issuing injunctions against the release of these illegal immigrants and saying that there is some kind of civil offense going on, and therefore it nullifies this sense of criminality of being an illegal alien. This sanctuary city issue is not going away, and I think you're going to hear a lot more about that. All right, Section 2 also refers to persons of service that could not free themselves by escaping to a free state. Now, obviously, that was made null and void by the 13th Amendment, which made slavery illegal. So that wasn't going to happen again. All right, Section 3 starts getting into the federal government's relationship with the states. And this is where we start getting into federalism and what are states' jurisdictions and what are federal jurisdictions. Section 3 starts to talk about the admission of new states and territories. Now remember, we weren't the 50 states at the time. We were just the 13 colonies, the 13 states, but we also had territories that would become new states. Section 3 accounts for the power that Congress can admit new states, but they cannot form them out of another state's jurisdiction. In other words, they couldn't have taken Pennsylvania and taken the northeast corner of Pennsylvania and made it a new state. Nor could they combine two states together without the consent of those state legislatures wanting to do that. For example, just because Rhode Island is so small and easy to pick on, they were protected in this case because you couldn't just go in there and say, hey, you know what, Rhode Island they don't have enough space. Let's just shove them together with Connecticut and call it a day. That gave that state power. So here's the respect that, was going to be shown to the states. All right, Section 3 also talks about territories and their jurisdiction. Now, so the federal government was going to have full jurisdiction over these territories, and they used that to their advantage when it came to slavery. So when they had decided, when the abolitionist movement was starting to get stronger and the northern states were starting to let go of slavery, they would say, because the federal government had jurisdiction over that whole territory, they would be able to say, you know what, that whole territory is going to be a non-slave holding area, and we're going to turn them into states. They had the ability to do that and to dictate that because territories did not have constitutionally explicit privileges that the states had. Now, once, of course, they became states, they would adopt those privileges, but not before. And this applies to territories that we have now, like American Samoa, Guam, the Northern Mariana Islands, Puerto Rico, the U.S. Virgin Islands. These are U.S. territories. They are not states. All right, moving on to Section 4. The Guarantee Clause. The Guarantee Clause establishes that every state is guaranteed a Republican form of government. This clause is insurance for the states to ensure the fact that they would remain under the rule of law. They would have this, that the federal government had to stay within the bounds of the Constitution. Remember, there are 3 rules when it comes to a republic. The government is accountable to the citizens. There's not going to be a monarchy established. And the rule of law is supreme. The federal government was expected to protect federalism under the rule of law. The states would be able to have their independence and their protection under the federal government. Okay, and this brings up a good question about how a republic is so very different from a pure democracy. We are not a pure democracy. In a republic, the Constitution protects all the way down to the individual. And that cannot be taken, those individual inalienable rights, and that cannot be taken away by any level of that government. That right is supreme over the whole system and hierarchy of government, even if the majority of the voters decide we don't want it like that anymore. Too bad. The mob does not have the right to overpower the individual. In a pure democracy, the majority is not restrained in this way. And their will can be imposed on the minority or even the one person. And I think you can see that today in these unruly riots and mob mentality of Antifa, where they're coming in, and you got so many forces at work here. you've got these police departments that are basically told to stand down. And then you've got these rioters coming in that are just seeing, full open door policy with their conduct. And they come in and, they feel justified coming in and hunting down and pummeling, beating up, even though they're Nazis standing for what they think is right, and we don't necessarily all agree with that. The mob is being allowed to just destroy those individuals, and that is not constitutional. That is something you must always protect against. We are not a nation where the majority rules. We are a nation where the Constitution rules. Okay, that's a lot of information. Take a quick break, and we will come back with Article 5. Okay, we're going to pick it up again here with this Article 5 slide where we talk about amending the Constitution. Now, we've talked several times about these rising political factions of the Federalists and the not so necessarily named the Anti-Federalists. But, that term implies that Federalists are more in support of this group effort at the federal level of the government. The Anti-Federalists were more concerned with the states and individual rights. So at this convention, of course, you have both factions debating these issues, and they weren't going to let this they weren't going to let this convention end without an ability to amend this Constitution. Because, first of all, they weren't even going to ratify it unless they knew that there were going to be some amendments that we now call the Bill of Rights attached to this document, the Constitution, and made law as well. The founders neither wanted, too much rigidity in the system that would make it absolutely impossible to amend. Like with the Articles of Confederation, every single state had to ratify it. Well, you're never going to get anything passed if you're looking for complete and 100% buy-in. So they wanted, but they also didn't want it to be so easy that you could just come in and this thing could be ever changing. So they come up with Article 5, and we'll go over that in the next slide, but you should know that right after the ratification of the Constitution, they get in there and get those 10 Bill of Rights amendments ratified, and then you have a lot of amendments that come in, of course, around after the Civil War, because now, we're going to make sure it's constitutional that slavery is absolutely forbidden in the nation. And then for yet even another 100 years in the South, the Democrats had a stronghold on the political parties there, and they did not want to let go of this power they had over the slaves. Essentially, they just wanted the segregation to be there, and they just couldn't let go of that. So this kind of just keeps bubbling up with the poll tax and the testing, be able to vote, and the Jim Crow laws. They just cannot let go of this stuff. So this came to a head after the Second World War, and the Civil Rights Movement really kind of, that brought out Martin Luther King, and that really brought the civil rights laws and amendments into play, and there's a lot of activity after the 60s. Now, there's something worth noting here, and that's that up until 1808, you could not violate Article 1, Section 9, the first and fourth clauses of the Constitution, And if you look at those, what it is they're saying there was a protection in there for the slave trade, and they were going to put that in force until 1808. So there never could be an amendment that would violate Article 1 or Section 9. Article 1, Section 9, first and fourth clauses. Okay, so let's get on to what Article 5 actually reads. And I'm just going to read it out, and then we will, then I'll explain it a little bit, because there's two ways you can amend the Constitution. The Congress, and I'm reading from the Constitution, the Congress, whenever 2/3 of both houses shall deem it necessary, shall propose amendments to this Constitution, or, on the application of the legislatures of 2/3 of the several states, shall call a convention for proposing amendments, which in either case shall be valid to all intents and purposes as part of this Constitution, when ratified by the legislatures of 3/4 of the several states, or by conventions of 3/4 thereof. As the one or the other mode of ratification may be proposed by the Congress, provided that no amendment which may be made prior to the year, here we go, 1808 shall in any manner affect the first and fourth clauses of the 9th section of the first article, and that no state, without its consent, shall be deprived of its equal suffrage in the Senate. So in the first case, 2/3 of both houses of Congress may propose amendments. And after they come up with the amendment and 2/3 approve of that, they've got to send it back out to the states for ratification. And there has to be 3/4 of the states ratify it before it will become law and become part of the Constitution as an amendment. Now, the other option is I think, specifically designed for that case when, the people have been completely eclipsed from their power in government. In other words, when a government is out of control and is not responding to the people, you can't tell that government to go make amendments and make amendments and laws that are going to, curb its own power. They're just not going to do that. So this option allowed the people the power and the states the power to come back in and say, whoa, federal government, we're going to make some changes here, and you're going to have to adopt these changes. And that's what that second option is. 2/3 of the state legislatures need to apply for there to be a convention of the states. Now, the federal government, the only thing Congress has to do in that case is say, here's the day and here's the time. Okay, they really don't have any other option. There's going to be a convention of states if 2/3 of the states submit these applications. And equally, as when it's called out of Congress, anything that comes out of this convention of states must be ratified by 3/4 of the states to become an actual amendment to the Constitution. Now, I'd say those two options are exactly what the convention wanted to achieve, as far as a flexibility, but not so easy, because there's flexibility here to come in, and obviously we have 27 amendments, so we have been able to achieve this goal, but not so easy, because you've got to have 3/4 of the states buying in on this, and that is no easy achievement to come by. The second option in Article 5, where the state legislatures call a convention of states, is actually taking hold pretty strongly right now in the United States. There's 12 states that have passed these applications, and there is a huge momentum of effort to keep moving and getting the 2/3 of the states to fully come around and make these applications and therefore have a convention of states. This is a grassroots effort. And the reason why grassroots efforts works is because you don't have one single power kind of directing a bunch of people. You have a bunch of people focusing their energy on achieving one goal. And they're all independently coming to this of their free will. So that's why grassroots efforts are incredibly effective in the United States. And it's because their structure is completely counter to centralized power. It's a more widespread net of people coming together for one effort. And you really can't stop that. If that's what they want, that's what they're going to get. And by being organized, they have the ability to come in and actually achieve this effort, I believe. But we'll see. And there are a lot of students your age that participate in this movement. And it should be an inspiration to you that you're not too young to care about the future of your country. And you're not too young to come express what's important to you before your government leaders. Do that now. Get in the habit of that now and make your voice heard now. And later, you're going to have way more control over your government than our generations ever had. Okay, we're going to move on to Article 6 and Article 7, and this is the last slide. All right, Article 6 is the delineation that the Constitution is the supreme law of the land. The Constitution and the laws of the federal government are considered to be the highest authority of the nation, and judges are bound to that law. This article is also known as the Supremacy Clause. And within this, also, as with the judges and as with the president, the senators and representatives must take an oath to support the Constitution. But something very important here that they throw in is that they cannot be subjected to taking some kind of religious test that says, that proves that they're of some denomination or of some specific creed or religion. That is absolutely forbidden. All right, moving on to Article 7, which reads, "The ratification of the conventions of the 9 states shall be sufficient to the establishment of this Constitution between the states, so ratifying the same." Now, what's important here is that Rhode Island did not attend this convention. So 3/4 would have been 9 states. So, and they did end up getting unanimous consent of the states present at the convention. So it did ratify, of course, but it was proposed for ratification on September 17th, 1787. And this is known as today as Constitution Day. And every year, schools are expected to celebrate this week that surrounds the signing of the Constitution. And in Texas, we call it Freedom Week. And the schools are expected to, push that education of natural rights, of inalienable rights, of the Bill of Rights, of the constitutional foundation of principles. These ideas are indeed crucial to the preservation of our nation. So I encourage you to, even when you're out of school, when you have children of your own and you're sending them to school, make sure they're doing that. That's important to the future of our nation and to those children's future, to always understand the principles of freedom as established in the United States. There just is no better gift to give a child than to know that they are naturally free. Don't just memorize the preamble to the Constitution, understand it, and teach it to children. The founders of this nation sacrificed their lives, their fortunes, and their sacred honor, just so that they could secure the blessings of liberty for themselves and for their posterity. And that's you. So don't let go of that. Don't ever, ever let go of that. All right. Here's where like the grand music and stuff is supposed to start, but I'm not going to do that. So even though I'd like to, I am inclined to do that because I feel so strongly about this topic. But there you have it, the United States Constitution. You guys have a fabulous rest of the day, and I will see you next time in government class at GW Bridge Academy.